MCQ of Indian Evidence Act 1872. As per the preamble of Indian Evidence Act 1872, the purpose of this act is to consolidate, define, amend law relating to evidence. The object of Indian Evidence Act 1872 is set out in its preamble is to consolidate, define, amend law relating to evidence. The Indian Evidence Act 1872 applies to all judicial proceeding in or before any court. The Indian Evidence Act does not apply to the proceedings before the arbitrator, affidavit submitted by the deponent of his own. As per Section 1 of Indian Evidence Act, the Act come into the force on September 1, 1872. Under Section 1 of Indian Evidence Act, the proceeding which specifically excluded from the operation of Indian Evidence Act is proceeding before arbitrator. The Indian Evidence Act 1872 applies to all judicial proceeding before or in or before any court. Which one of the following statements are correct? The Indian Evidence Act applies to the proceeding whose object is to determine the juror relation between the one person to another. The Indian Evidence Act is not applicable to Jammu and Kashmir. Not relevant now. In the case of Kashmira Singh versus State of Madhya Pradesh is related to confession of co-accused. Oral evidence. What is oral evidence? A statement made before court. Which one of the following statement as per the provision of Indian Evidence Act 1872 is not correct? Not correct is the fact which is inconsistent with the fact in issue shall not be relevant. Which one is correct? Fact not otherwise relevant if by themselves or in connection with the other fact the making of the existence and non-existence of any fact in issue or relevant fact is highly probable and improbable. Any fact is relevant which show or constitute a motive or preparation for any fact in issue or relevant fact. Admission are not conclusive proof of the matter admitted, but they may operate as estoppel under the provision of Indian Evidence Act 1872. Which one of the following is a fact? Han said, Mohan saw, Ram told. All of these are fact. An inscription on the metal plate or stone is a document, right? Document produced in the inscription. Document produced for the inspection of the court include a written document, a caricature, a electronic record, an inscription on stone. That there are certain objects arranged in certain order at the certain place is a fact. An inscription on a metal plate or stone is a document. In relation to expression defined Section 3 Indian Evidence Act, Which one of the following statement is not correct? Quote includes arbitrator. Which one is correct? Fact include not only physical fact but also psychological fact. An inscription on the stone is a document. The fact is said to be not proved when neither proved nor disproved. Which one of the following is not include an expression of the court under the Indian Evidence Act? Arbitrator. An evidence means an include ocular and documentary evidence both. Documents are caricature, word printed on lithography, photography, a map or the inscription on the stone. All of the above. A fact is said to be non-proved when it is neither proved nor disproved. An inscription on the metal places a document true. What is the meaning of not proved under Indian Evidence Act? Neither proved nor disproved. In the relation to Indian Evidence Act, which one of the following statement is not correct? Court include arbitrator. Which one is correct? An inspection on the metal place is document. A fact is said to be not proved when it neither proved nor disproved. A state of a person is a state of the person. Health is a fact. Which one of the following does not fall within the meaning of the term court used under Indian Evidence Act 1872? Inquiry commissioner, legal advisor, or excise officer is not a court. Which one is court? Revenue tribunal, industrial tribunal, registrar court is a court. According to Indian Evidence Act, a fact is said to be not proved when the court a fact neither proved nor disproved. Which one of the following term has not been defined under Indian Evidence Act of Section 3? Confession. Whether a weapon is deadly weapon is a question of fact. In law of evidence, fact means an include anything perceived by senses, state of thing capable of being perceived by senses, mental condition of which a person is conscious. All of these. Fact can be physical as well as psychological. Electronic record produced before the court is documentary evidence. Under the Indian Evidence Act, evidence does not include identification proceeding, condition of witness at a time of giving evidence, fact of which judicial notice can be taken. All of these does not include evidence. Under Indian Evidence Act, the evidence may be given in all cases about fact in issue or relevant fact only. Indian Evidence Act in an evidence under the Indian Evidence Act means and include both ocular and documentary evidence. Which one of the following is not a fact? Mental condition, relation of a thing, state of things are fact, so none of the above. Which one of the following is not has been mentioned in the definition of documents as the means by which any matter is expressed or described upon the substance? Evidence Act under Indian Evidence Act include both ocular and documentary evidence. Which one of the following is not a fact? Mental condition is a fact, relation of a thing is a fact, state of thing is a fact. Which Which one of the following has not been mentioned in the definition of document as the means by which any matter is expressed to describe upon the substance is symbol. A fact when it is neither proved nor disproved is said to be not proved. Which one of the following does not come within the meaning of document under Indian Evidence Act? A telephonic talk. Under the Indian Evidence Act, fact means factum provendum, that is fact in issue, and factum provend, that is relevant fact. Fact in issue means the fact, existence, and non existence of which disputed by the party. A fact is said to be proved if its existence is so probable that a prudent man would accept its existence. Evidence means and include a statement of a witness required to be made before a court. The fact alleged by the one party and denial by the other in the case are termed as fact in issue. Not proved means it is neither proved nor disproved. Proof is a result of evidence. The fact sought to be proved is called factum provendum. An affidavit given by the court is not an evidence. Which one of the following is required to prove essential relevant fact? In the Indian Evidence Act, the expression court means all judges, all magistrate, all the person except the arbitrator legally authorized to take evidence. The term court is defined in Indian Evidence Act 1872 does not include arbitrator. Which one of the following qualities to be treated as a fact within the meaning of assign it to under the Indian Evidence Act? Man heard and saw something, the man hold a certain opinion, the man act in a good faith, all of these are fact. According to the Indian Evidence Act, a fact is said to be not proved when fact is neither proved nor disproved. Under Section 3 of Indian Evidence Act, the court does not include arbitrator. A is accused of the murder of B. At his trial, which one of the following will not be a fact in issue? That A had gone a field with the club. Which one is a fact in issue? That A intended to cause the death. That A had received a grave and sudden provocation from B. That A caused B death by beating with the club. Evidence means and include both oral evidence and documentary evidence. The fact in issue means fact, existence and non-existence of which is disputed by the party. What is the meaning of not proved under Indian Evidence Act? Neither proved nor disproved. In the relation of expression defined under Section 3, the Indian Evidence Act, which one of the following statement is not correct? Court include arbitrator. When one fact is declared by Indian Evidence Act to be conclusive proof of the another, the court on proof of one fact shall not allow the evidence to be given for the purpose of disproving it. Evidence under Indian Evidence Act means both ocular and documentary evidence. The fact which is neither proved nor disproved is said to be not proved. Which one of the following is not considered as a evidence? Affidavit. Fact in issue means fact, existence and non-existence of which disputed by the party. A fact neither proved nor disproved is known as not proved. Which one of the following does not fall within the definition of the term court under Indian Evidence Act? All person legally authorized to take evidence. All consumer forums are not a court. In the relation to expression definition of section 3 Indian Evidence Act, which one of the following statement is not correct? Quote include arbitrator. A fact is said to be when it is neither proved nor disproved is not proved. According to the Indian Evidence Act, a fact is said to be not proved when the fact is neither proved nor disproved. Whenever it is directed in the Indian Evidence Act 1872 that court shall presume a fact, it shall regard such fact as provided unless and until it is disproved. Under the Indian Evidence Act 1872, which one is not a evidence of the following? Personal knowledge and observation of judge about the case during the hearing is not a evidence. Which one is evidence? Statement of a dumb witness is evidence. Document proceed by the inspection of the court is evidence. Electronic CD is evidence. Making the fact in issue is it is a duty of the court. Which one of the following is a fact? Sohan saw a cow. Mohan said Sohan to go. Sheetal has a high reputation. All of these are fact. Which one of the following can be considered in the evidence in any suit or proceeding under Indian Evidence Act? Fact in issue and relevant fact. Indian Evidence Act apply to both civil and criminal proceeding. The reputation of a person is a fact. Which one of the following is not a court as per the definition arbitrator? Income tax appellate authority is a court. Witnesses describe the detailed article decorating in the room while giving a statement before it. This is the fact. What is the definition of not proved in the under Indian Evidence Act? A fact is said to be not proved when it is neither proved nor disproved. Anything, state of thing, relation of things capable of being perceived by senses is a fact. What is the following is not included in the expression court under the Indian Evidence Act arbitrator. In the relation to the expression defined under section 3, the act which does not following statement is not correct. Court include arbitrator. Under the law of evidence, the relevant fact is must be legally relevant. Which one of the following statement is not correct? A map or plan which intended not to be used as evidence is a document. Check upon the banker of a document is the evidence. Power of attorney is the document. A writing contain the direction and instruction is a document. Whenever it is provided by Indian Evidence Act that court may presume a fact, may call for a proof of that fact. A fact is a conclusive proof of another fact. If the fact is proved by, the court shall regard another fact as proved. What is shall presume in regard of the fact? Court shall presume the fact as proved unless it is disproved. Under the Indian Evidence Act 1872, court has no discretion regarding the proof of fact contains of conclusive proof. The law of evidence under Indian Evidence Act is a procedural law. The law of evidence is a procedural law. Considering the following statement, the proceeding of the Parliament and State Legislature of India as a judicial noticeable of the fact and criminal law in force in India is a judicial noticeable of the fact.